Harassment. What is the crime of harassment in Texas? What is the state of Texas required to prove in order to convict you? Hi, I'm Jeff Hampton with the Hampton Law Firm. Today I want to talk to you about the crime of harassment. And I want to thank you for coming to our YouTube channel and going over some of the law that we're going to provide to you under Texas criminal statutes. And this is kind of a strange statute because it changes all the time. There's been a lot of developments, and I'll be frank with you, if you study the crime of harassment in Texas, it's a little unsettled in terms of what the law is. So I want to thank you for joining us. If you wait around to the end of this video, I'm going to give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, so the crime of harassment, at first glance, it looks like it's not a big deal. I mean, what is this? I haven't really hurt anyone. I'm harassing them. What does that mean? I'm annoying them. And there is some truth to that element, but understand it's an arrestable offense, which means you could have a criminal record, you could end up with a conviction, which could make it difficult for you to find a good job. And here's the other thing. Many employers see a harassment charge and conviction as as a sign that maybe someone's unstable. Maybe someone has some mental health issues. You don't want to be labeled with that. So it's important that you fight your harassment charge so that you get the very best result that you can possibly under the law. Now, what qualifies as a harassment charge in Texas? Usually it arises when an alleged victim receives some form of communication from the accused. For example, maybe an in-person visit, maybe an email, maybe some text messages or phone calls. And that, as a result of that contact, it, quote, annoys or alarms them to the point of calling the police. Now, the biggest challenge for the police will involve proving that you were the person, number one, that made that communication and that you actually acted with criminal intent. We're going to get into those defenses here in just a minute. For example, there are times when criminal intent can be inferred based just upon what happened. For instance, we've seen cases where someone literally called someone 500 times in 24 hours, and they called and left multiple messages over and over again. In that situation, you may be able to infer criminal intent much easier. Or maybe a particular phone call or a voicemail was left where there was a specific verbal threat that was made, maybe a threat of bodily injury against that person or a family member. In that situation, it's a lot easier for the state to be able to prove criminal intent. But some of the more common examples of how people are charged with the charge of criminal harassment is, let me give you some examples. Maybe communication with someone with the intent to annoy them, describing certain things, or saying you need to do this or you need to do that, and those sort of things repeatedly over and over and over again makes it more objectively likely that a jury would believe that they were done with the intent to annoy or alarm. Now let's look at Texas Penal Code section 42.07. It says that the state of Texas must prove the following elements of harassment beyond a reasonable doubt. Here's what it says. A person commits an offense of harassment if, with intent to harass, annoy, alarm, abuse, torment, or embarrass another, he initiates communication by telephone, in writing, or by electronic communication, and in the course of that communication makes a comment, request, suggestion, or proposal that is obscene. And we'll talk about what obscene means here in a minute, okay? Number two, threatens by telephone, in writing, or by electronic communication in a manner reasonably likely to alarm the person receiving the threat, to inflict bodily injury on the person, or to commit a felony against the person, a member of his family or household, or his property. So the first is obscene communication. The second one is threatening communication, literally making a threat against that person or a family member of that person. Number three, conveys in a manner reasonably likely to alarm the person receiving the report, a false report, which is known by the conveyor to be false, that another person has suffered death or serious bodily injury. Good example of that is if someone calls and says, this family member of yours has died, lying about it, putting that person to alarm them in order to scare them, that would be that example number 3. Then we go to number 4, causes the telephone of another to ring repeatedly or makes repeated telephone communications anonymously or in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another. All right, that's just calling somebody like crazy. That's basically what that's saying. And then the next one is to make a telephone call and intentionally fails to hang up or disengage the communication. You see what we're talking about here? All right, and then the last one under the law, knowingly permits a telephone under the person's control to be used by another to commit an offense under this section or sends repeated electronic communications in a manner reasonably likely to harass or annoy or alarm another. All right, now here let's talk about it. I told you what that definition of obscene would mean. That's under Texas Penal Code section 42.07B3 says obscene means containing a patently offensive description of or a solicitation to commit an ultimate sex act. And you know what that is. Basically, some type of obscene messages that are sent, okay? So let's talk about this for a second. The more common example, I would say probably 90% of the time, someone is charged with harassment is where it's related to electronic communications or telephone calls that are repeated in nature, okay? Now let's talk about this. Can electronic communications be considered harassment in Texas? Now look, everyone has a smartphone now. Everyone sends messages. Everyone sends emails back and forth. So the most common example of electronic communications that have been used to establish harassment claims have been what? Social media posts. They've been messaging through apps or text messages. And until recently, sending an alleged victim repeated messages through an electronic communication would have been seen as probable cause for an arrest and could be moved forward as a harassment charge. However, it must still, even in the past, old law, it must still have been shown that they were sent with the criminal intent to annoy or alarm the alleged victim. However, right now, remember I told you at the beginning of this video, the state of harassment law is a little in flux. Well, that's because the Texas Court of Criminal Appeals, their decisions have somewhat limited the use of electronic communications as a basis for harassment and some stalking charges as well, because those are closely related to each other, okay? And so why? Well, the courts have ruled that many electronic communications are essentially First Amendment protected. It's free speech based, okay? And think of it this way. If someone keeps sending you text messages, what can you do? You can block them. Right? You can also block their email. So many of the courts have said, nah, not real sure about that. We're going to say that that's not valid. That's critical for you. There are many detectives who do not know this. They are still not up to date on Texas law and the changes that have been made through the recent Texas Court of Criminal Appeals rulings. Okay? Now, how does Texas harassment law define threatening communication? Because we talked about what threatening, there is an element of threatening communication for one of the examples. First, it's critical to remember that the state must always prove beyond a reasonable doubt that the communication was threatening, all right? And it must be so objectively. So in order for them to meet their burden, they would have to look at the context of the messages to determine if they are overtly threatening or not. So a message that is, and here's what your lawyer needs to be looking into. Let's say the message is vague. Let's say it's ambiguous. Let's say that sort of situation where it may not have been directed at a particular person. That can pose a problem with the prosecutor for them being able to prove their case. Most threats, in order to be proven in a jury trial, will need to be specific to the alleged victim and specific enough to make it clear that the intent was credible as to time and place as to what was going on. That's precisely the reason why you need to make sure that all these messages that the prosecutor are relying upon are analyzed thoroughly, okay? Now, can you go to jail for harassment in Texas? Yeah, technically you can. Under Texas law, the crime of harassment is a Class B misdemeanor, punishable by up to 180 days in jail and up to a $2,000 fine. So I'm not going to go through a lot of the legal defenses here for you, but I do want to identify, number one, if it's electronic messages, your first offense is that the messages were actually First Amendment protected speech under the law. And so if that's what your detective is relying upon in order to try to claim harassment, that's the first area your attorney needs to attack. Now, what's the next area? What about lack of criminal intent? What if the communication was sent to someone that was reasonably annoying or alarming, but there was no criminal intent? In other words, what if the communication took place for some other purpose other than the intent to annoy or alarm? Remember, there must be specific criminal intent that it was sent to annoy or alarm. Now, I'm going to give you an example. We see this very frequently take place between divorced parents communicating over their kids. We've had clients who have sent text messages like we had a client that we basically had a father that sent a message to the wife or to the mother, and they had been divorced, about the kids. And this client sent something over saying, basically, I heard that our son was seriously injured and taken to the hospital. All communications, he continued to message back and forth. The ex-wife basically cut off communications, and for over 8 hours, all communications had stopped. So he was sending multiple messages, calling, doing this repeatedly. Of course, why? What was the intent? His worry was that he was worried that his son was seriously injured and wanted to determine the status of his son medically. His ex-wife, though, think what she did. She wanted to use this as an advantage in divorce court or in family court. She turned around and tried to claim that the frantic messages were a basis for harassment, that he was harassing her. We later learned that the alleged injury to the child never even actually occurred. It was something that was just thrown out there that, of course, kind of baited him into this conduct. So it's important to understand the state of Texas must prove that the messages were sent, the communications took place with the intent to annoy, alarm, or harass another, okay? Finally, the communication, what if the communication was not actually reasonably annoying or alarming? So the very nature of the question shows that it is an opinionated conclusion, is it not? So what might be annoying or alarming to one person may not be to someone else. And so as a result of that, look, we've actually seen communication that's arguably very benign and lacks aggression, and a reasonable person would differ on whether or not it met that definition under Texas law. So that goes back to you don't have to prove anything. The prosecutor's got to prove everything. Okay, so these are just a few of the examples of some things you might be able to do as far as a legal defense if you or a loved one has been charged with the crime of harassment in Texas. And listen, I promised you if you waited around to the end of this video, I would give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. All you have to do is click the link down below, send in your email information. We'll send over that free ebook to you immediately. And by the way, if you are charged, or you or a loved one has been charged with the crime of harassment in the North Texas area, maybe in the Dallas or Fort Worth area, we would be happy to provide you a free case analysis. The number that you've seen above the screen here the entire time I've been talking is our contact information. I want to invite you to call our office, and we will be happy to give you a free case analysis. And listen, I want to thank you for joining us here today on our YouTube series. I look forward to seeing you on our next topic.